Well, I'm really looking forward to this one. Today on Straight Talk, I have Russ Kendzior. He's the chairman and founder of the National Floor Safety Institute, or NFSI. Our topic today is an interesting one because it touches so many people and organizations. Today, we're going to cover demystifying litigation on slip, trip, and fall legal issues. Russ Kendzior, welcome to the program.
You're welcome, Jeff. Good to see you.
Are we going to tell lawyer jokes or just get right into it?
Well, maybe. We'll see what we come up with.
Okay. You know, this topic about litigation, anyone that takes care of floors, cleans them, maintains them, people that own buildings that have floors that people could slip on, this has to be a topic they're interested in. Tell us this, when it comes to litigation and legal issues, Russ, what surprises you the most about litigation tied to slip, trip, and fall situations?
Well, that's actually a good question, Jeff. I've been doing work as a expert witness, taking cases for about 25 years. Been retained on almost 1,100 slip, trip, and fall lawsuits. And that's all I do, just slips, trips, and falls in pretty much every state in the country. And just when you think you've seen everything, something new comes along. But it's a very, very common problem. In fact, it's all, again, based on the fact that slips, trips, and falls are one of the leading drivers for emergency room visits, for accidental death, accidental injury in pretty much every industry. And so, people fall for a lot of different reasons. And what's kind of interesting with the advent of surveillance videos, many of the cases I'm presented, the actual incident, the event is captured on video. So it's not like in days of the past where somebody would describe what happened and then you tried to put it together like a detective, like, putting together the evidence. Now it's captured on surveillance video. So what happened, the event itself kind of speaks for itself. So when somebody is slipping and falling on an alleged wet floor or tripping and falling over a entranceway floor mat, you can see it. You can see exactly what happened. And also you can see what the condition of the floor was prior to the fall, meaning was it really wet and for how long? And how did it become wet? Was it because somebody was mopping the floor, 20 minutes, 30 minutes earlier, perhaps didn't put a wet floor sign out? All of those factors now play out in litigation. It makes it a little bit easier for those like myself who take projects involving slips, trips, and falls. And it works both ways, Jeff. Defendants can protect themselves by that same surveillance video. If in fact there was no hazard or the floor mat wasn't buckled or curled, which oftentimes is the case, the defendants can use that as a defensive means by which to protect themselves. But at the end of the day, the surveillance video is capturing all of this. So everywhere we go, it's kind of like a spy movie. Everywhere we go, we're being watched.
So Russ, I have to think that you've seen some pretty funny videos, some acting going on.
Most of the time when I'm given a surveillance video, I'm already retained as an expert. The attorney's already filed a lawsuit. There's a certain amount of discovery been processed, meaning data, information, an incident report, the surveillance video, photographs, et cetera. And so by the time I'm retained, it's the case is kind of far along. For example, I'll be retained in a case maybe a year or two after the fall. And so what happened actually happened a long time ago. And because of the legal process taking a long period of time, especially with COVID, a lot of courts were closed and juries were not permitted to testify. And so seeing that surveillance video at my stage, it's usually more graphic, not funny. Sadly, you bring up a good point, though. When we see somebody slip and fall or trip and fall, we instinctively laugh. We do think it's funny, even though the resultant injury can be very, very serious, even death. For some reason, Jeff, people around the world, when we see somebody slip, trip, and fall, we laugh. It's just kind of funny. And that's why I wrote a book called Falls Aren't Funny.
Yes, I was thinking more of the ones who try to pretend they fall, who are trying to look for that lawsuit. But you're right. By the time it gets to you, that's already been fleshed out.
Yeah, those are rare.
Okay.
The insurance industry estimates that slip and fall or trip and fall fraud is somewhere around 3 to 5%. Most fraud are matters involving slips and falls. Why? Because it's easier to stage that. You just kind of sit on the ground and point to a puddle of water and say, look, I slipped on it. Fraud is less common with trips and falls because it's harder to fake it without getting hurt. Chances are you're probably going to get hurt if you trip and fall. But realistically, the vast majority, between 90 and 95% of slip and fall and trip and fall events, not just lawsuits, but events, are legit. That 5%, though, Jeff, of fraud are generally criminals, people that do it professionally. They're not staging one event. They'll do it over and over and over and over. They go from town to town staging slip and falls or trips and falls. They're not looking for big settlements. They'll be happy with $10,000 or $20,000, which sadly, the insurance industry is more than willing to pay them. And so they just kind of make a business off of a lot of small claims where generally by the time I'm retained, there's big damages. There's medical damages of between $100,000 and $200,000, $300,000. So it's a big deal. And it's usually because there's a serious injury.
Yeah. In our previous episode, I know you talked about one case was like something like $20 million from the court, but let's ask a simple question. How does the cleaning industry, those that maintain floors, stay out of the courtroom? Can you touch on maybe settling out of court? How often does that happen? How does this all work?
Well, most of your members have insurance. And so they have an insurance policy that if somebody slips and falls or trips and falls and they're sued, their insurance company will defend them. Now, it seems like for many people that defense is free. It's far from free. That's why premiums continue to rise every year, because it's not free. Now, in many of those cases, the defendants, say it's a janitorial company or a building service contractor, they can simply argue in front of the judge, look, we had nothing to do with this event. Our people were not on staff during the day. We weren't even there. This had nothing to do with us. We come in later at night and clean the floors. And what will oftentimes happen is the judge will administer a summary judgment whereby the building service contractor is discharged, meaning they're not going to be a party to the suit. Now, that doesn't always happen. Oftentimes, they have to go through the whole process. Now, medical costs are one thing, legal costs are another. Lawyers, again, are not cheap. And when your insurance company is picking up the bill, they want to get out for the least amount as possible. So again, depending on the event, it can be very, very serious and very, very costly. But for a building service contractor, the easiest three things they can do is, number one, monitor the performance of their floors. If you're cleaning the floor with a cleaning product or cleaning equipment or a floor finish, are they NFSI certified? Are those products proven to reduce slippage? Do they make floors safer? If you're coming in with your brother-in-law's floor cleaner, all right, that he makes up the street, then you really don't know what effect that cleaning product or maintenance process has. And that's a weakness. That's where a plaintiff attorney is going to exploit, logically. And so make sure you're using cleaning products and procedures that are not making the floor slippery. Number two, how often do you actually test your performance as a building service contractor? How do you know that when you're cleaning people's floors that you aren't in fact making them more slippery? Do you do any testing? Do you bring out any testing equipment? And I don't mean every time, Jeff, but maybe, once every quarter, monitor the performance of the floors. In fact, do that before you take the contract. You may be inheriting a slippery floor condition from another contractor, and now when somebody falls, it's your fault. So the best way to protect yourself is to measure the floor before you sign the agreement, let your client know that there's a hazardous condition, and then you work towards remediating or fixing that problem. And then lastly, it's all about education, performance, inspections. Who's monitoring the floors? How well are your people trained? Are they looking for hazardous conditions? Do they even know what that means? For example, if you're using a mop from a kitchen to clean a kitchen environment, are you then using that same mop in a hallway or a bathroom? Well, now you're cross-contaminating surfaces, which is a bad thing to do for sanitation purposes, Jeff, but it also takes the grease from the kitchen, and now now you're greasing up the bathroom floor. And so training, education, testing, and using the right products to make sure you're not contributing to your client's slip and fall problem, because that lawsuit may come back to you.